out live transcript. Okay, greetings, students. It is the 5th week in the module. This is, I think it's module 11. Anyway, so it's the last office hour of week 5, and there's an assignment due at the end of the weekend. And so next week is the last week. I think what I'll do is the first office hour of next week, I'll also discuss the exam. What you can kind of expect, what are some approaches. So, and then, yeah, and then you'll have like a week off or so before the exam. Any questions on any comments or questions on anything that we've done so far? Okay, if not, we're going to talk about extradition tonight. So this is another example of a category that's in the procedural realm. And also the so in order to prosecute someone, you normally need custody, although a lot of countries allow in absentia criminal prosecutions. So that means a lot of states, a lot of civil law countries will allow the adjudication of a criminal offense without the presence of the defendant, especially if there's evidence that the defendant had notice and then just didn't show up. That's not allowed in the US. Prosecution by absentia. It is allowed in the US if the trial has already started and then the defendant absents himself. In the discretion of the judge, the trial can still go on. Sometimes I've done cases where I've done extradition cases where the relator was convicted in absentia. And so I have argued that in certain countries, the retrial process is not fair. So for instance, I had a case once, I did it with the International Human Rights Law Clinic at American University, Washington College of Law, where a person was convicted in absentia in France. He was a New Zealand person charged with basically narcotics offenses. And so my argument was that he wouldn't get a fair trial. He was found he was found extraditable, and then he appealed to the or he tried to get habeas corpus. It was denied, and then he appealed to the Court of Appeals in New Orleans, and then before his hearing, suddenly he was sent to France. The US position in the last 15 or 20 years is that you only get one appeal. So if you do a habeas corpus and you lose, but you don't get a stay, the government, if it wants, thinks they can extradite you. So in that case, when the person arrived in France, um, he went to court and the judge said, okay, you've been convicted. On retrial, do you have anything to say? Any evidence to add? And I mean, it basically lasted about an hour or two. And they reaffirmed his conviction. And he was held and then sentenced in one of the oldest and worst prisons in France. Yeah, so and then, one of the things we're going to discuss the extradition process, alternatives to extradition. So so it's very important in the extradition process to know a lot about the procedure in the other country. So, I mean, one of the first things I do is I say, look, we got to have the best lawyer in the other country, or else, we're not going to be able to argue that the laws of the requesting country were violated, or the procedures weren't properly followed, because I know US law, but I'm not a member of the bar, and I can't ever say that I know well the laws of another country, especially if it's not even a common law country. But obviously you have to become very familiar with the laws of the other country in order to properly represent the person. And with globalization, there's a lot more extradition cases, although during the pandemic, extradition has slowed quite a bit because it's not so easy for the marshal to get on a plane to go over and take the person and then sit. They have to sit right next to him in a plane coming back to the US. And there's a shortage of resources in the Department of Justice and the US Marshal, who has to get the people, has to get the fugitive. And so extradition has slowed down a lot. So when the US is the requested country, the request normally goes to it always goes to the State Department. State Department reviews the request and then passes it on to the Department of Justice. Normally, the review by the State Department isn't, all that tough, because they know the Department of Justice, Office of International Affairs, is going to look it over very carefully. Every now and then, it's possible to get the State Department to not send the request on. I mean, I had a case involving a grandson of a former head of state in Venezuela, who was charged with, he was just charged with normal crimes, namely conspiracy to murder his mother and his sister, and his sister was murdered. His mother almost died. She feigned, drowning in her own blood in the bathtub, and they left. But the case was highly political, I argued, and it worked. With the State Department didn't send on the extradition request to the Department of Justice. Even when the Department of Justice gets the case, a lot of times they say this case is not going to succeed. And so what they do is they call up their counterpart and they say, look, unless you improve the extradition request, it's not going to make it. So we're not going to send it on because it's a waste of time. We don't want to, waste our limited resources. So, you've got to do a better job. And here's what we think is lacking. You've got to show better probable cause. You've got to do A, B, and C. And sometimes they'll send it back 2 or 3 times in order to ensure that the requesting state does a better job. So then finally, once they get it and they think it's been done properly, they will then send it on to the U.S. Attorney in order to process the case. So importantly, the federal rules of criminal procedure and the federal rules of evidence don't apply, because the U.S. government will, of course, represent the requesting state. The U.S. government only has to prove a probable cause that, case has been, that an extraditable offense has been committed, and that the person arrested is the person who is the person who's been identified as the extraditee. And so they don't have to show that much. The relator, the relator is a term synonymous with fugitive or defendant. He cannot introduce evidence to prove his innocence or to rebut the government's evidence. He can only present evidence to clarify or explain the government's evidence. It's like a fine line on what's rebutting versus what's clarifying or explaining. But bottom line is, some courts don't allow the relator to, introduce a lot of evidence, and there's no discovery, although you can ask for it. The relator doesn't have the ability to cross-examine witnesses, especially most of the testimony is not even in person. Most of the testimony is an affidavit from some law enforcement official that says, I investigated the case, here are the facts, here's the law, here's the criminal complaint or the indictment, and here's some other evidence. Sometimes there'll be 2 or 3 affidavits, but the relator doesn't then have a chance to confront very well the evidence against him or her. So the initial hearing is before a U.S. magistrate or judge to determine, whether they've got the right person and whether there's bail or not. And bail is usually not granted. In order to get bail, you've got to show that you've got strong ties to the community. Like, you're either a US citizen who's been living in this place for all of your life, or that if you're a foreigner, that you have also strong ties with the community, and that if you're released, you won't pose a danger to the community, and very important, you won't be a flight risk. And usually the US attorney, usually the prosecutor is going to say, this guy's going to be a flight risk, and you shouldn't give him bail. And because these cases can take years, a lot of times if people don't get bail, they sometimes will waive extradition, because sitting in a US jail is not very nice. So when you get to when there's an extradition hearing, then the questions will be whether the US government has established that there's probable cause evidence that establishes the relator's identity, that the charges are extraditable offenses within the relevant treaty, and that the charges fulfill the requirements of dual criminality, as well as any other treaty statutory requirements. And if the person is found extraditable, he can try to petition for habeas corpus. But even if he does, habeas corpus is a much narrower, there are narrower grounds on which the court can review the finding of extraditability. So, and if the relator wins the habeas corpus, the US government can appeal, and ultimately, even if the US government loses on appeal, they can file a petition for writ of certiorari to the US Supreme Court. And if they still lose, then the relator is released, or if he's already out of, if he's already out on bond, he's a free man, but he or she better get his ass out of the US, because if he or she remains in the US, the US can file a new extradition request, and the process can start all over again. But normally, that doesn't happen unless there's new circumstances. Yeah. So then there's, so when the US is a requesting state, there are, well, again, the US is going to want to have, well, both the US and the relator will want to have really good attorneys in that other country. And the relator, in addition to having a really good attorney in that country, is going to want to have a good attorney in the US. Now, when the US is the requested state, if the relator doesn't have money to hire his own counsel, a public defender or a criminal justice act indigent defense counsel will be appointed. A lot of times that's not so good, because they often do not have expertise on extradition. So for instance, in the last 5 years, I've probably been a consultant and an expert witness for about 5 different public defenders. They do have most of them have what's called a rainy day fund. So they have a pot of money when they need to hire an expert. So that's when they reach out to someone like me, and I will advise them, on the extradition strategy, and sometimes I will make an expert opinion. So when the US is the requesting state, note the case of Kobe Alexander on page 421. He was basically wanted for fraud in Namibia, and he very smartly invested a lot of money, basically gave a lot of money to build low-cost housing in some urban areas where it was badly needed. And he became, very popular with the government in Namibia. And so for a few years, the US got nowhere with his extradition, with the extradition request, because he basically curried favor with the Namibia government. And this, shows that extradition is a mix of law on the one hand and politics on the other hand. So they go hand in hand. So sometimes good politics will go far. So once in the 80s, there was a case where the US indicted a guy named Mark Rich. Do any of you know that name, Mark Rich? He was a um, basically a trader, a commodities trader, and he was indicted for Iran sanctions. He basically he sold oil to Iran just when the US was ramping up sanctions against Iran. And so he was charged with violating the oil pricing statutes for trading with the enemy, and also for intercompany pricing, which is rarely prosecuted as a crime. He got the best lawyers, and he even got a public relations firm, which then hired me. And basically what I did was I did briefs for the Swiss government, because he was trying to get permanent residency in Switzerland. And eventually his extradition was denied by the Swiss government, and he got permanent residency, and he lived happily ever after. And then at the very end of the administration of Bill Clinton, on the very last day, Mr. Clinton pardoned him. And it just followed some very substantial donations by Mark Rich's wife to the Clinton Library. And again, shows you, if you curry favor, it may not only save you from being extradited, but it may even ultimately get you pardoned. Extradition treaties. So on page 424, you have an example of the US-Belize treaty. Can you Belize it? They use the Belize treaty is an example of some of the older treaties which use schedule of offenses. The modern treaties just say, if you are charged with a serious crime, which is usually defined by imprisonment of 1 year or more, and it's a crime in both countries, then that's an extraditable offense. Whereas in the Belize treaty, there is a schedule of extradition offenses. So you can see, you can see on page 430 and 431, the schedule of offenses under the US-Dutch 1983 treaty. So if you're a relator, it's much easier to defend against extradition if you've got a list of offenses, because a lot of times they don't change the list and modernize it so that, for instance, it has all the new cyber crimes and so forth. So that's why the US, for instance, when it or I should say, when Panama requested the extradition of its former president, Martinelli, for violating, for surveilling people's computers, they used as the basis for their request not only the US-Panama Treaty, but they also used the cybercrime, the Council of Europe Cybercrime Convention, as the basis for extradition. So that also shows you that wherever possible, you use as a basis not only the bilateral treaty, but multilateral treaties as well. Starting on page 431, of the text, you've got the US statutes that apply to extradition. So those statutes are going to come into play. Also, there's a circuit split on when a relator can raise specialty doctrine. So specialty means that if the US requests my extradition, let's say from Spain, for crimes 1 through 5, and Spain says, we're only going to extradite him on crimes 1 through 2. When I'm extradited to the US, the US shouldn't be able to prosecute me for crimes 3, 4, and 5. And in addition, the US should be precluded from having a superseding indictment, which often happens. Now, some of that doesn't matter as much, because if I'm convicted and sentenced in the US, the judge usually can take into account all of the surrounding circumstances. So even though I'm not convicted for crimes 3 through 5 or new crimes, the judge still may take those into consideration on sentencing. Although if the judge isn't careful, I can probably successfully appeal. So, what are the grounds to deny extradition? Sometimes you might find in your final exam, an open-ended case where you'll be given some facts, and the question will be, okay, advise Mr. X or his counsel on what are the grounds to deny extradition. So one of the traditional grounds are that many countries, especially civil law countries, under their constitution or under their statute, they don't extradite nationals. Now, the US has fought very hard to have countries change their laws. So for instance, they've convinced a number of countries. The US will say, look, we extradite our nationals without hesitation. So, you should reciprocate and agree to extradite your nationals as well. Because, especially in a lot of cases where the evidence is going to be in our country, it's not going to be possible for you to effectively prosecute crimes. And a lot of times your own nationals may be victims, because a lot of times when there are violent crimes, it's a family member who's going to be a victim. A lot of times the spouse or the child or a parent that are victims of violent crimes. So a number of countries like the Netherlands have amended their extradition statute, and they say, okay, we will extradite our national, but only under the condition that if we extradite him and he's tried and prosecuted and convicted, that he's allowed to return to serve his sentence in our country. So that's called, prisoner transfer. Now, in some cases, I had a case involving a Dutch person who was charged with a Foreign Corrupt Practices Act case, even though he never came into the US. He just participated in a phone call where there was a discussion of bribing a Panamanian official in order to get some preferences. And so we tried to work out a plea, but we basically said, look, the longest sentence he's going to serve is 2 years under the sentencing guidelines. And we know that it takes 18 months usually for a prisoner transfer application to be processed. And if it's approved, then the court a court has to adjudicate and make sure that the person who's about to be transferred, says he realizes he's giving up his right to appeal, et cetera, et cetera. And courts often don't even hear those cases for 3 to 5 months, and then they often don't issue a decision for another month or two. And then it takes time for the marshal to, get the guy and put him on a plane. And so by the time his application for transferring would be decided, he's going to serve more time than his sentence. So unless you can find a better way, unless you can guarantee that he's going to be transferred right away, we're not going to plea. And in those cases, in that case, the US said, sorry, we're not able to do that. So we said, fine. Our client is not going to enter into a plea. He's going to stay in Holland the rest of his life. Although Holland's a small country and he might not be able to travel, he prefers to, live in Holland than to spend a couple of years in a US detention facility, especially because he won't even go to, a detention facility that is the normal one that he should go to. But anyway, extradition of nationals is important. A lot of countries like France, they just don't extradite their nationals. Jurisdictional issues are important. It's the crime, normally the extradition treaty says, unless the requesting state has jurisdiction, the requested state doesn't have to extradite. So I almost succeeded with the public defender in a case called Inocente Orlando Morales. Spain was trying to extradite him because he was allegedly involved in the massacre of the Jesuits in El Salvador in the height of the El Salvadoran Civil War. But he was a dual national, El Salvador and Spanish, but he had lived at the time of the of his murder. He had lived for something like 30 years in El Salvador. And so I said, under public international law, there is something called the law of dominant nationality. If a person is a dual national and one state wants to assert certain rights over that person, and there's a conflict between two jurisdictions, then there's a principle of the right of dominant nationality. And in this case, man, he'd left Spain a long time ago and he was only back a couple of times. So he was really an El Salvadoran citizen, and therefore, court, you've got to rule that there's no jurisdiction, and therefore you've got to deny the extradition request by Spain. And the court took a long time, had several hearings, said it was a close call, but in the end, no cigar. Mr. Inocente Morales, despite his name, Inocente, was sent to Spain. There used to be, well, there still is, exclusions for military offenses. There used to be exclusions for tax offenses because of the revenue rule. But the modern treaties say that, especially the US ones, say that a person can be extradited for tax offenses. There's there's something in the chat. Oh, am I the only one that got that joke? Okay, that's good. Statute of limitations. Each treaty has different provisions on statute of limitations. Some say you use the statute of limitations for the requesting state. Others say the requested state. But that sometimes can be important. Double jeopardy is important, although the US has a very narrow double jeopardy ground. So to give you an example, I had a case once where somebody was prosecuted in the state of Texas for conspiring to murder his wife. He was in California when she was murdered. He was acquitted, but then the federal prosecutor in Texas, in one of the Texas districts, indicted him almost for the same crime. He, moved to dismiss on the basis of double jeopardy. He'd already been tried. But, the court said, well, no, it's a different sovereign. And therefore, it's, your motion is denied. So he quickly, he quickly left the country, ended up in the Netherlands. US went to extradite him. I served as a consultant and an expert witness in my expert affidavit. I said, look, the US is in the dark ages when it comes to double jeopardy or non bis in idem. The international rule is much broader, and therefore, Dutch, you should deny his extradition. The judge agreed and denied his extradition. And, the guy lived happily ever after in Holland. Lack of identity is another potential defense. Lack of dual criminality is often an important defense, because even though the modern trend is that the courts liberally say, well, if it's the same conduct, even though there are different elements for the offense in our country versus the other country, we're going to extradite them. But a lot of times, modern crimes like cyber crimes or sanctions, export control, a lot of countries don't have a similar law on sanctions. And even if they do, unilateral US sanctions are very controversial. And so sometimes the court will hang its hat in the other country on lack of dual criminality on an export control offense. Capital punishment is often a reason to deny extradition. So, states like Texas have, capital punishment. The big case is Suring, where a German youngster, he was a student at UVA. He went with his girlfriend from UVA to visit her parents. Things went bad, and her parents were murdered. He was arrested in England. He appealed his case to the European Court of Human Rights, and they found he should not be extradited because of the death row syndrome. They said, look, most of the people that are subject to capital punishment in the Commonwealth of Virginia spend many years on death row in very horrid conditions. So it's tantamount to cruel and unusual punishment, and therefore it would be a violation of the article on cruel and unusual punishment to extradite this youngster, unless the US, on behalf of the Commonwealth of Virginia, promise that if he's prosecuted and convicted, he won't be given the death penalty. Commonwealth of Virginia so promised. Mr. Soring was extradited. He was convicted, and a couple years ago, he was basically released, but only after serving like 25, 30 years. The case was very close to whether he did it or whether his girlfriend did it. But there's also the short case called the Blender case, where a US serviceman in the Netherlands killed his Turkish wife and tried to dispose of her remains in a blender. Hence the Blender case. The Dutch court said, no, he can't be extradited because of same thing, potential capital punishment. Well, the US was trying to forcefully take him out, but the Dutch, found out and prevented that. And again, the US finally had to give guarantees that they wouldn't subject the guy to the capital punishment. There have been a number of cases where humanitarian or international human rights have decided the case, such as Pinochet, the former head of state of Chile. In your text, there's some discussion of his case. Eventually, because of his age and his medical conditions, the Home Secretary found that even though he was extraditable, they weren't going to extradite him. The big case to follow right now is a case of Mr. Assange, the founder of WikiLeaks. I'm sure a lot of you know about his case. Back in January of last year, a lower judge ruled that the US had a case to prosecute Assange, but the UK couldn't extradite him because the US authorities had not provided any adequate guarantees that they could safely deal with him. I mean, essentially, he's had a number of very good lawyers and non-governmental organizations lobbying on his behalf and saying that if he is sent to the US, he might be kept in maximum security. And no, I haven't consulted on that case. He might be kept in maximum security and he might commit suicide. And so, but then in October, the US then gave assurances. And so another court reviewed it and they said, well, we think that these assurances are okay. We think they're satisfactory, but there's a question of whether the US gave assurances timely. And so, the court is still considering whether now the US timely gave those assurances. As you may recall, Mr. Assange spent a number of years in the Ecuadorian consulate where he got asylum, but he made a nuisance of himself because he was skateboarding and he managed to father 2 children. And the Ecuadorian consulate is very small, and he basically was taking up about 2/5 of it and just making a nuisance of himself, making all kinds of statements, including, helping the Russians and Mr. Trump during the 2016 elections. And so eventually the Ecuadorians, threw him out. And because he had avoided hearings in Britain on extradition requests by Sweden for his sex offenses in Sweden, the English threw him in jail, and he's been detained ever since. So the political offense exception is rarely used. You've got to show that the exception arises out of some political, some incidents of violence. You can't just say, look, they're prosecuting me because I used to be the president or I used to be the minister of finance. That doesn't cut it. The rule of non-inquiry is basically that if you say, I can't get a fair trial in that other country, because as we know, the country is, has a lot of human rights issues. Normally the US judiciary says, sorry, we don't entertain the rule of non-inquiry, because if that was a problem, we wouldn't have an extradition treaty. We let the executive branch determine whether the system is fair. So that's why the Justice Department, the State Department say the US can't have a treaty with Russia. But that, but now and again, well, other countries use that all the time. So in 2019, New Zealand rules against a returning South Korea national to PRC due to concerns over torture and chances of a fair trial. That happens a lot when China is the requesting country. And that's also why I believe the US doesn't have an extradition treaty with China for the same reason. But you know, it could be potential, the rule of non-inquiry. I mean, that there is dicta in some cases that show eventually a US court may entertain the rule, I mean, may entertain the lack of a fair trial. So alternatives to extradition, they include deportation. They include rendition. Rendition can involve either acceptable conduct or conduct that violates precepts or is highly suspect. So for instance, I've been an expert witness in 2 cases recently involving Cambodia, where the US requested extradition from Cambodia. Cambodia has a very detailed extradition law, and eventually Cambodia did return the 2 people. And then when they got to the US, they faced superseding charges, superseding indictment. The US said, they tried to say, well, rule of specialty and also dual criminality. You can't prosecute me for this crime because it's not a crime in Cambodia. And the US said, sorry, you weren't extradited, you were just renditioned, you were surrendered informally. I said, no. They were extradited by comity, and therefore they are entitled to all the rights such as dual criminality and specialty. So the court has to decide, is this extradition by comity or is it just rendition? So this stuff, by the way, isn't in the book. But you know, they are cases that I've recently been involved in. There's also luring. Most countries accept luring. The Eunice case is the big one. There's also discussion of 2 cases I was involved in where 2 individuals were lured from their countries. So I brought an action in the Inter-American Commission on Human Rights, but I did not succeed. Basically, the commission takes years to even take the case, and then they often decide that, as in the case of Mr. Walker, the Canadian, they decided he didn't exhaust his remedies in the US, his judicial remedies, because you know, he didn't want to come back to the US because he had been in pretrial detention for long enough. And when the commission wouldn't hear his case at first, he took a gun and tried to commit suicide. He became paralyzed in one side of his, in one of his, you know, sides. And so, fortunately, I used that to get the commission to finally convene a hearing. Abduction is the US and some countries follow the principle malacoptus bene detentus. So we don't care how he was caught, as long as he's before the court, we're going to take jurisdiction over this guy. Although, you know, if it is so bad, like the guy's tortured and so forth, there's 1 or 2 cases where US courts have not followed the principle of malacoptus bene detentus. The big case is US v. Alvarez Machine, where the doctor that helped keep alive while he was tortured, Kiki Camarena, the former DEA official in Guadalajara, who was doing such a good job of exposing the cartel and exposing the political corruption in Mexico, that the cartel kidnapped him 2 days before he was supposed to leave his post. And then they tortured him for 2 or 3 days. And Mr. Alvarez Machain was the doctor. So when Mexico wouldn't extradite him, the US, with the help of a corrupt police officer of Mexico, went into his office in Guadalajara, kidnapped him, put him on an airplane, and sent him to Los Angeles. Two courts, the trial court and the Court of Appeal, said, no, he can't be tried here. He was brought illegally. But the US Supreme Court, in a 5-4 decision, said, no, it doesn't say, the extradition treaty says nothing about kidnapping. And so it's okay. Mr. Noriega, same thing. He was kidnapped, brought to the US. I actually was summoned by Mr. Noriega to help him for his appeal. And I actually spent longer than I had anticipated, because there was a problem in the prison, and the prison was locked down for 2 hours. So, I was able to spend quite a bit of time with Mr. Noriega. He had the treatment of a prisoner of war because he was head of state. But lo and behold, he said he had exhausted his funds. And so I said, although I'm very sympathetic with your appeal rights, not so sympathetic that I'm going to take this case without getting paid. And so I ended up, and he lost anyway, his appeal. He spent about 20 some years in the US. And then he was extradited to France, where he spent another 3 or 4 years. So there are extraordinary renditions. The US used them a lot after 9/11. There are a few cases where in Britain allowed victims of extraordinary renditions to sue high-level officials. Miss D'Souza, who was a CIA agent, that was her undercover, but undercover she was working in the consulate in Milan. She helped give evidence. She basically helped to kidnap, although she personally didn't kidnap, Omar Abu, who was wanted for his the things that he did in 9/11. He was brought to, I think it was Morocco, where he was tortured. And so later on, the Italians prosecuted the Americans that were involved in his kidnapping. And one of the CIA agents, Miss D'Souza, she eventually lost her job at the State Department because she couldn't travel anymore once she was indicted. And so she went through Portugal on her way to Goa to visit her mom, who was very ill, was basically on her deathbed. But she was arrested on the European arrest warrant, and she basically was adjudicated. She was convicted by a Milan court, although she was they eventually commuted her sentence. She was initially sentenced in absentia, but then because she was contrite, and also because Italy didn't want to piss off the US by, sentencing her to imprisonment, she eventually only had to do public service for her violations of Italian law. But she also tried to sue the US government. Actually, a friend of mine, Mark Zaid, took her case. She tried to sue the US because they failed to represent her, before the Italian courts. Can you imagine? They wouldn't even represent her. Partly because they didn't want to admit that, number one, she was a CIA agent, and number two, that she was involved in the kidnapping. Her case was thrown out because there was a lot of classified information, and the court couldn't properly adjudicate her case without getting to the classified information. And so it threw out the case. I also had a client, one of the people the Italians went after, but for whatever reason, they, dropped the case against him. He had trouble once coming back from a foreign, where he was abroad. There was a case in 2017 where the German government expelled Vietnamese press attaché over alleged kidnapping of a Vietnamese living in Germany. And so the moral of the story is, while some courts will recognize kidnapping, that a lot of countries will try to prosecute the people that are involved in the kidnapping, including even, government officials. And also, they sometimes will take action against the governments involved. And then I guess the other alternative to extradition, which I don't really mention in the book, is what countries like Russia do. They, try to poison people. I mean, they basically authorize assassination. You also saw that in the case of Saudi Arabia, in the case of the Washington Post journalist who was a permanent resident in the US. He went to Turkey to get his passport renewed, and they had been surveilling him through his social media. And when he tried to resist being arrested and going back to Saudi Arabia, because they didn't like a lot of the things that he'd been publishing about the lack of freedom of press and the lack of due process in Saudi Arabia, he was basically murdered, and they cut up his body in little pieces and disposed of it, and tried to, they tried to say it didn't happen, but the Turkish government has prosecuted some of the individuals. Saudi Arabia has also prosecuted some of the individuals. The US has, released some reports, but so that's, still another alternative to extradition. There's an NGO that puts out, a US NGO that puts out reports on efforts to intimidate and assassinate expatriate dissidents. Countries like Turkey, Russia, Saudi Arabia. There's a whole host of countries that do alternatives to extradition. I mean, I don't mention it in the book because it's really, extra legal, but that is another, alternative to extradition. So let me stop here. Any comments or questions on anything that we've done? Or okay, one question regarding assignments. I no longer see assignments to be submitted on the 27th. Huh, what do you mean? That's not on the it's not on the canvas? Well, if it's not, I will look and put it back. I mean, a couple of people have already handed in their writing assignments for assignment 3. So, that surprises me. And I just looked yesterday to see the timing, or I guess I looked after our last class, but I'll look again.
Well,
And any other,
is he saying the 27th? Because there wasn't a writing assignment for the 27th, was there? It's just the 21st.
oh, right, it's the 20, yeah.
21st.
There was a writing assignment at the very beginning of the class. It said 20th and 27th. But
Yeah, no, it should. No, the third and last assignment is due on the 21st, which is,
okay.
I think that was a confusion. It was the same assignment,
basically
but it had
midnight.
2 different
midnight
dates.
Sunday.
Oh, I see. Okay. So it was the same assignment, but it was okay. I get it. Thank you.
Yeah, sorry about that. Okay, any other questions or comments? Okay, hearing none. Thank you very much for your attention and enjoy the rest of your week and weekend.